Good morning, colleagues.
I call the meeting to order. Welcome to meeting number 98 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order adopted by the House on February 7, 2023, committee's meeting in public to continue its study of Bill C-332, an act to amend the criminal code controlling or coercive conduct. And as you know, today's meeting is to go through clause by clause. Members are attending in person or virtual, and I believe we have no witnesses outside the members. And of course, I'll introduce in a moment the persons in front of us. So I think members by now know what the rules are if they're attending virtual. I think we're okay with that. There's no other witnesses attending virtually. So I just want to welcome our officials that are assisting us today for our clause-by-clause study on Bill C-332. Nathalie Levman, Avocat Conseil,
Senior Counsel, Criminal Law Policy Section, and also Ellen Wiltsey-Brown, Counsel, Criminal Law Policy Section, the same section. So welcome to you.
Being with us, we will count on you for any technical information that we require on any of the amendments or anything that any of the members want clarified, or even me as the chair wish to have clarified. So I'm ready to start with clause by clause. I just want to give a few instructions first, as I'm mandated, I think, to do. So as you all know, it's an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in the bill or in the package each member received from the clerk. Members should note that amendments must be submitted in writing to the clerk of the committee. The chair will go slowly to allow all members to follow the proceedings properly. Amendments have been given a number in the top right corner to indicate which party submitted them. Once an amendment is moved, unanimous consent is required in order to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. These sub-amendments must be submitted in writing. They do not require the approval of the mover of the amendment. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Once every clause has been voted on, the committee will consider and vote on the title and then the bill itself. If amendments are adopted, in order to reprint the bill is required so that the House has a proper copy for use at a report stage. Finally, the committee will have to order the chair to report the bill to the House. That report will contain only the text of any adopted amendments as well as an indication of any deleted clauses. So I will now move to clause-by-clause consideration. I'm going to use these notes. These were your notes, I think. So before the chair, that's me, calls clause 1, there's an amendment on page 1 of the package seeking to create a new clause 0.1. Mr. Maloney, would you like to move G-1?
Yes, I would, Madam Chair. Thank you. This is a straightforward amendment which seeks to amend the code to require that anybody convicted under this new offense be subject to the their name be added to the prohibition order, whereas offended is convicted with respect to gun prohibition.
Shall G-1 carry, or does anyone have anything to say on that? Okay, shall G-1 carry as amended? Yes. I'm sorry, just carry? Yes. Okay. So it is carried. Now we go to clause 1. G-2. Mr. Maloney.
Yeah, I would, Madam Chair, I would like to move this amendment. It's a substantive amendment, and I believe that it reflects a lot of the evidence that we heard before us over the course of the discussion in the last few weeks, and reflects the consultations that had taken place in the process leading up to the discussion of this piece of legislation. It reflects, for example, the what we've been referring to as the Scottish approach. It changes the nature of offense. It focuses more on the accused. It addresses concerns that were raised throughout our discussion, which might, as previously proposed, result in victim reliving some of these horrors that they had been put through, and I think that the amendment is quite comprehensive, changes some of the terminology, and captures much of the language that we all, I believe, supported during the course of our debate. So I will leave it there, Madam Chair, and look forward to hearing from others. Thank you.
So before, Mr. Fortin. So before we continue, I have to inform you, if G2 is adopted, BQ1, BQ2, BQ3, Lib1, BQ4, BQ5, CPC1, and BQ6 cannot be moved. Cannot be moved due to a line conflict. As House of Commons Procedure and Practice, 3rd edition states on page 769, amendments must be proposed following the order of the text to be amended. Once a line of a clause has been amended by the committee, it cannot be further amended by a subsequent amendment, as a given line may be amended only once. I now have a list of speakers. Can you also put Mr. Moore? And before we go to the list of speakers, I'm personally going to ask the staff that is here to support us to provide us a bit of a technical explanation.
Thank you, Chair. I'd be very pleased to give a technical overview of the various components of the proposed provisions in this motion. So, this proposed coercive control offense would prohibit engaging in a pattern of conduct, which is the act element of the offense, with intent to cause the accused's intimate partner to believe their physical or psychological safety is threatened, or being reckless as to whether their pattern of conduct could have this effect. This is the fault or mental element of the offense. In respect of the mental element, proposed subsection 264.011, a person who intends to cause their intimate partner to believe their safety is threatened either desires that outcome or is virtually certain that their conduct will result in that outcome. A person who is reckless as to whether their conduct could cause their intimate partner to believe their safety is threatened, is aware that their conduct is likely to have that result, and proceeds to engage in the conduct despite that risk. This approach is closely modeled on the mental element in Scotland's domestic abuse offence, but uses terminology that has meaning in Canadian criminal law. For example, intimate partner is defined in Section 2 of the Criminal Code to include current or former spouse, common law partner, or dating partner. Pattern has been interpreted in the context of the dangerous offender provisions to apply where conduct is engaged in at least twice. And safety has been interpreted in the criminal harassment and human trafficking context to include psychological safety. Now moving to the act element of the offense, proposed subsection 264.012. The act element is, as I've said, engaging in a pattern of conduct, and that is defined as any combination or repeated instances of any of three types of conduct. First, violence, including attempted and threatened violence towards the intimate partner, the intimate partner's child, their animal, or anyone known to them. Second, coercing or attempting to coerce the intimate partner to engage in sexual activity. And third, conduct that could, in all the circumstances, reasonably be expected to cause the intimate partner to believe their physical or psychological safety is threatened. Notably, the first two categories of conduct constitute criminal conduct in and of themselves, and the last category encompasses subtler forms of conduct that are generally non-criminal behaviors in other contexts. The definition of this third category of conduct is informed by the Criminal Code's definition of exploitation for the purposes of the human trafficking offenses, which uses an objective test and relies on the concept of physical and psychological safety. Appellate jurisprudence interpreting that definition clarifies that the test is objective, meaning that the focus is on whether the conduct could reasonably be expected to have the prohibited consequence and not on whether it actually had that consequence. In particular, proof that the victim actually feared for their physical or psychological safety is not required to meet the test. A non-exhaustive list of examples of this third category of conduct is provided to assist criminal justice practitioners in identifying conduct that could reasonably be expected to cause a complainant to believe their safety is threatened, including more subtle forms. This list is informed by relevant legislation in other jurisdictions, as well as input from Justice Canada's 2023 engagement process, including the lived experiences of survivors. The list highlights that abusers may engage in subtle forms of abuse that do not constitute criminal offenses in and of themselves, and that may not be readily recognizable as coercive, particularly if considered out of context. This approach is also informed by the coercive control offenses that have been enacted in Scotland, New South Wales, and Queensland. Clear Act elements may also assist with interpreting and applying the offense. For example, courts may infer the offense's mental element from evidence that the accused repeatedly engaged in the prohibited conduct. Moving now to the interpretive provision, proposed subsection 264.013. This provision directs consideration of the nature of the relationship between the accused and the complainant, including whether the complainant was in a position of vulnerability in relation to the accused. This factor is to be considered when determining whether any conduct could reasonably be expected to cause the intimate partner to believe their safety is threatened. The purpose of this provision is to assist in minimizing opportunities for the offense to be weaponized against the victim by requiring consideration of the whole context of the offending, and in particular, any power imbalance between the accused and their intimate partner, which is generally present in relationships marked by coercive control. Situating the alleged conduct in the overall context of the relationship at issue could assist in identifying the true aggressor, including in cases involving mutual intimate partner violence allegations. Turning now to the penalty provision, proposed subsection 264.014. The proposed penalty is a maximum of 10 years on indictment, which would treat the offense the same as criminal harassment and ensure its eligibility for dangerous offender and long-term offender designations. Finally, the for greater certainty clause in proposed subsection 264.015 clarifies that safety includes psychological safety, which is the same meaning as it has in the context of the Criminal Code's criminal harassment and human trafficking provisions. I hope that assists the committee and would be happy to try to answer any of your questions. Thank you.
Thank you very much. That explanation is extremely helpful and valuable as we continue to do clause by clause, and I hope it has benefited some of the members as well. I have a list of speakers, starting with Ms. Gladue, Mr. Caputo, Monsieur Fortin, Mr. Moore, Mr. Garrison, and then Madame Gladue, will start with you.
Thank you, Chair. You'll recall from when we were going through the testimony that I wasn't opposed to having a list. In fact, I think that a list of what constitutes coercive control will be very helpful in the training of police officers and justices. I don't really like this list compared to the list that England had, because I think there's some problems in this one. If you think about the limit on medications, I was thinking of some of my family members that are bipolar, for example, and sometimes they think they're feeling well and they don't want to take their medication, and their partner basically forces them to take their medication, otherwise they really escalate into a bad place. So, that's one of the things that's considered coercive control in this list. So I would rather not have the list in there. I thought that originally having a list would mean more convictions, but we heard testimony that out of the all the ones in England, 6% of the cases that were brought forward saw prosecution, and out of the 700 that were prosecuted, only 3% saw a conviction. So I'm not sure that this is going to actually fix the problem, and I think there might be a couple of things in the list that are problematic, so I prefer not.
Thank you, Ms. Gladue. I would like to receive a response from our guests, I guess, that are here to help us specifically to what Ms. Gladue has mentioned.
Thank you. Yes, it's important to remember that none of the conduct that's listed in that list can be considered prohibited conduct for the purposes of the offense unless it is considered in all the circumstances to reasonably be expected to cause the intimate partner to believe their physical or psychological safety is threatened. So that is the legal test. That conduct is illustrative of types of conduct that could meet that test, that we know has met that test in real lived experiences, but the test would need to be met before it could be considered prohibited conduct for the purposes of the offense.
Ms. Gladue, are you okay with that? Do you have another anything to add on that?
On to Mr. Caputo.
Mr. Caputo, please.
Thank you as well to our subject matter experts here. And I appreciate what you said, that really, if I hope I don't paraphrase incorrectly, but what I took you to say is that the legal test requires the outcome, as in the intent to do this, or it's reasonable that this is going to follow, as in the wording in the act that a person would fear. Again, I'm paraphrasing. My concern, though, is obviously that's when we get to the point of conviction, right? At that point, you're before the judge or jury, as it may be, and when we're looking at things like controlling physical appearance or access to health services or medication, my concern is that perhaps we are muddying the waters about what this does entail. I mean, obviously, none of us want to see coercive behavior. None of us want to see any behavior that's isolating. So, like Ms. Gladue, I do have some issue with, especially on the medication end, or a person expressing spiritual beliefs. I mean, this is something that couples are often going to discuss. And at what threshold or at what point does that bleed into criminal behavior? That line, I understand the test that you've enunciated, but that line is less clear for me. So I'm not looking for an answer from the experts. I'm just intervening with some concerns.
Thank you, Mr. Caputo. I personally would like to know if you have anything that you can share with the committee and the public at large who is listening and who has a stake in this on that exact point.
As I said in relation to the other question, none of that conduct can be prohibited conduct or can be considered coercive conduct for the purposes of this offense unless it meets that safety test. It has to be considered to be reasonably expected to cause the intimate partner to believe their physical or psychological safety is threatened. But in addition to that, we have to remember there is a mental element that also needs to be proven, which is either intent to cause the intimate partner to believe that their safety would be threatened, or being reckless as to whether that would ensue from their conduct. So there are a lot of protections built in to ensure that that list of conduct is truly just illustrative and based on the lived experiences of those who have gone through this horrific or being subjected to this horrific crime or soon to be crime, perhaps. It's up to you to decide that. But it's very carefully crafted to ensure that only the person who is holding the power in that relationship, only the person who has the power, not the vulnerable person, would be captured by it through both the intent element and the way that this third category of conduct is defined with respect to a legal test that has, by the way, a lot of appellate jurisprudence interpreting it, so we do know what it means, at least in the context of human trafficking, which is an overlapping type of crime. Thank you.
Thank you very much. Yes, Mr. Caputo, please. Yes.
Thank you. That's very helpful. So just so I'm really clear here, let's take sub 6 as an example. A person must cause their intimate partner to believe that their partner's safety is threatened, or they're reckless to the belief that their safety is threatened if they engage in conduct that controls the intimate partner's expression, thoughts, opinions, or religious or spiritual beliefs. So the connection there is that the person has to, that the victim in this case has to feel a threat of personal safety, a threat to their personal safety that the accused either intends or is reckless to based on how the person is expressing their spiritual beliefs. Do I have that right?
I think first you need to go to the legal test that's in the third category of conduct, which is whether or not the conduct could reasonably be expected to cause the intimate partner to believe their safety is threatened. So that's the first analysis that a court would need to struggle with. is the way in which that particular accused is seeking to control those forms of expression, could that reasonably be expected to cause the intimate partner to believe their safety is threatened? And then in addition to that, the intent element or the mental element would also require proof. Now that could be inferred from multiple examples of prohibited conduct. For example, if the accused engaged in violent conduct, sexually coercive conduct, and also some conduct from this third category, which is any conduct that could reasonably be expected to cause the intimate partner to believe their safety is threatened. And these are just examples of different ways that we've seen in the literature and the research that coercive controllers have sought to control their victims. But it has to be read in the context of the overall offense. And it has to be remembered that that legal test will require proof. And it's an objective one, so it's based on what a reasonable person would think in that particular context, which is a lot like Scotland, New South Wales, and Queensland. They also ask for that analysis.
Okay, thank you. I just, last follow-up, I apologize. This is because it's very helpful. You're being very clear here. So the first element that somebody has, that would have to be proven beyond a reasonable doubt is that objective. It's an objective, not modified objective. Is that correct? It's an objective?
Well, some may say that you're also supposed to consider in the circumstances, in all the circumstances of the offending, which does require an analysis of that particular context, and then the interpretive provision helps with that to tell the person who's looking at, the criminal justice practitioner who's looking at that situation, to look at the whole context of the offending to try to identify where a power imbalance is, where a position of vulnerability is.
So we may actually be looking at this in part through the victim's eyes objectively, and then there's a requirement of proof of intent or recklessness. Okay, I'm sorry it took me so long to get to that.
No, you are correct.
Okay.
Yes.
Thank you.
Thank you, Mr. Caputo. Your questions are very helpful. Thank you for that. Monsieur Fortin, s'il vous plaît.
Merci. Merci.
Thank you, Madam Chair. And thank you to Ms. Livman, Ms. Wiltzie Brown for being with us today. And before I put certain questions, I've got a general comment to make. I was quickly reading through G2, and it seems to make sense. It seems to make sense, I repeat. And I understand that it respects our agenda that we set, but we received that on Friday afternoon, this Amendment G2. And I imagine I'm not the only one who was busy back in my riding, so I don't have time to bring together my team over the weekend and study this. Basically, we were rewriting the bill with G2. I'm not saying that it's not a good redraft, but it's problematic because we've heard from witnesses on the former bill, and on Friday afternoon we rewrite the text. On Monday morning we're meant to adopt it. It seems a bit quick off the mark in terms of procedure. I think it would have been advantageous to have worked with this new text as our basis, or at least have had one meeting to work on this text with witnesses. That was by way of introduction. My general comment. For all MPs, we have to have time to work on this. When we're just changing a phrase, a paragraph, a sentence, that's fine. But rewriting a bill on a Friday afternoon to vote on it on a Monday morning is kind of pushing it a bit. It's almost a lack of respect vis-à-vis the work of the committee. And of course, I'm showing full respect for my colleagues on the government side, who, of course, have the best intentions, but it does seem that we're moving a bit quickly on this. Having said that, is everything okay, Madam Chair? Can I continue? Yes, I do understand. I'm just checking the dates with our clerk, and he told me, well, I can see here that the amendments were sent to the committee members on Friday at 8:56 a.m. Well, I was told it was later, but, well, there's not much difference between midday or 8:56. But anyway, I had a General Council meeting, and then I had a tour at Quebec City and activities in my riding on Sunday. And I'm also trying to have a bit of private life now and again. I don't always have time to do that, but to get in a new draft at 10:50 on Friday, well, you understand. Yes, I very much understand what you're saying. I imagine that probably everyone has the same sort of issue. Well, I'm astonished that everyone around the table was just waiting for this amendment to drop from the government to work on that over the whole weekend, apparently. Anyway, having said that, I had prepared a certain number of amendments, and I do understand that my colleague from the NDP is going to collaborate with the government for the adoption of this. So perhaps I'm speaking into thin air for nothing, but it is rather disappointing to think that we've done all of that work and it was for nothing. I would have liked to have been informed in advance. So, for example, BQ1 and BQ6 that hang together. I don't know if we can put them into G2, but BQ1 said commits an offence, and we added in without reasonable cause when we were talking about the acts. And that was in the former version of the bill before G2. Could we include that in G2 at the same place? I think that would be appropriate, because in the current version we had a clause that would abolish BQ6. So it was a line to page 3 in French. No, sorry, I'm mistaken there. So it was line 26 on page 2, where it says the accused is acting in the best interest of the person. And we've heard from witnesses who have said that this could be rather troublesome, where one or the other said that they were, or thinks they were acting in the best interest of the person. It can vary from one individual to another. So I thought it was rather problematic in terms of the interpretation in the courts of this provision, or the interpretation that the accused could come up with, because any accused could say, I acted in the best interest of the person. As far as I'm concerned, I thought that was in his best interest, and then we could attack mens rea and acquit the person, possibly based on the belief that this person was acting in the best interest of the victim. So we thought that had to be replaced, and we had said 264.014, where without reasonable cause, everyone commits an offence who, without reasonable cause, who commits these offences in the bill. So that meant that the accused could say it's a reasonable cause that the courts can evaluate and assess. Well, how should I put it? Assess it not in a broader sense, but in a more general way, in a more objective way as well. Because if the individual's been accused says, I acted in this way and I prevented my spouse from going there, or my spouse from doing such and such thing, yes, that's controlling coercive conduct, but I did this because it was reasonable to do this in the circumstances. I thought it was reasonable. And then the court can then assess objectively whether there is this element of reasonable cause or not in the acts committed. So I think then we would be able to respect all the circumstances. We're trying to cover this is new legislation. We're talking about controlling and coercive conduct. No doubt everyone's come up against this vis-a-vis our children, for example, in our lives. And in a reasonable way, we thought it was necessary to act in a certain way. but it was probably often unreasonable, and we're now dealing with this issue, wanting to tackle it, and I agreed with Bill C-332, and I agree with all the arguments that have just been presented by our colleague, Ms. Collin. And Mr. Garrison has also expressed this argument in previous legislative periods. So I believe that the Parliament has to tackle these issues. But at the same time, when we're moving forward, we have to move forward cautiously. And I think it would be more prudent to say with reasonable cause, so that if the court judges that it was reasonable to act in this way, we would then be able to acquit someone and not send them to prison for 10 years if they were acting in a reasonable way in the eyes of the court. So this amendment, it's not on the agenda. We're on G2 and BQ1 comes later. But as we're basically going to scrap the rest of this, I'd like to know whether our witnesses agree with my interpretation, or have I erred on one side or the other? So if the experts say it could be wise to do this, can we make some sort of amendment? Let it up to you to decide on the practical side of things, Clerk and Madam Chair. But initially, could I hear perhaps from Ms. Levman and Ms. Wiltsey-Brown, what do you think about this question of the reasonable element? If we add an N2, 64.011, everyone commits an offence who, without reasonable cause, commits on a repeat basis these acts. And sorry for that lengthy question, but I thought it was necessary to explain the ins and outs of all this.
Madame Levman.
Thank you for the question. The government motion G2 is intended to address the concern that the accused should be able to avoid criminal liability if their conduct was reasonable in the circumstances. And specifically, it's because the proposed offense builds in a requirement that conduct that isn't criminal in and of itself must be reasonably be expected to cause.
Pouvez-vous juste nous référer à l'article au passage au...
Could you please refer me to the specific passage under G2 to which you're referring at the moment?
In proposed 264.012C, engaging in any other conduct, including conduct listed in any of the following paragraphs, if, in all the circumstances, the conduct could reasonably be expected to cause the intimate partner to believe that the intimate partner's safety or the safety of a person known to them is threatened. So it's built in.
Merci. Mais moi, c'est pas à cette raisonnabilité-là que...
Thank you very much, but that's not the reasonableness that I was talking about in my concern. So I'll let you put your headset on first. So under C, it's saying that in the cases where it's reasonable to expect that it would be possible to cause the intimate partner to believe that their safety is threatened, that's fine. But there are situations where the accused could say, yes, it's completely reasonable to think, well, it could be possible that she believed that her danger or her safety was threatened. But did I actually commit these acts without any excuse or without a reasonable cause? But if I did have reasonable cause in the eyes of the court to have committed these acts, in spite of the fact that it was reasonable for this person to believe that their safety was threatened. But if I had a reasonable cause to act in a certain way as far as I was concerned, then I should be able to be exonerated. And that should be able to be a valid defence. Do you understand what I'm driving at? It's two different levels of reasonableness. Under C, you're saying, is it reasonable in anyone's mind to believe that the intimate partner would have believed that their safety was being threatened? That is perhaps reasonable to think that they believed that. But did I act in a reasonable way? Did I have reasonable cause to act in a certain way? I don't know if this is clear, but there is a distinction between these two levels of reasonableness. they're not assessed in the same way at the same time. And I haven't seen that expressed in G2. And once again, I haven't been able to read through every line in detail under G2. I haven't time before this morning. I'm looking at, but of course, you have read it before this morning. That's quite obvious. So could you please reassure me on this? Otherwise, would it be possible to find a way of including that amendment of mine under G2?
I think the concern that you've raised is partially addressed by what I've already described in proposed 264.012C, but it's also addressed in the clarified intent element. A person cannot be convicted, or mental element, excuse me, a person cannot be convicted of this offense unless they actually intended to cause a person to believe that their safety is threatened or were reckless as to that fact. So if you have reasonable cause, or what you did was reasonable in the circumstances, that also is going to be reflected in what the person intended. And the intent element is unlikely to be made out as well. So you have two protections built into the offense as drafted, in my view. Thank you.
J'imagine qu'il est inutile de poser la
I imagine I cannot put the same question to Ms. Wiltsey Brown. I imagine she has the same opinion.
The same opinion, yes.
Merci. C'est ce que je pensais, mais ça me rassure. Là.
Okay, thanks. I thought that. That's reassuring. So, Madam Chair, I must admit I'm not completely reassured. Full respect there, of course, for Ms. Lebman. I've got a great deal of esteem for her, but that doesn't reassure me because this reasonableness test under 264.012C is not the same one as what we were proposing in BQ3, I believe. Yes. So I'm asking again, my colleagues and Mr. Maloney in particular, could we amend G2 to include an offence and then include the words without reasonable cause? I said BQ3, but in fact it was BQ1, corrects the speaker. So that was in this introductory part under 264.011.
Okay. La processus qui est
So, in terms of the procedure here, if you want to introduce that amendment, then you need to propose it in writing and express exactly how you want this amendment to be blended with this particular part in the sub-amendment. Well, the problem is that I can't submit it in writing because I just got it this morning. But I say it's BQ1. It's exactly the same text, mutatis mutandis. So it's clause 1, line 7, page 1, 264.011 in G2, which is the same as in Bill C-332, which says everyone commits an offence who, without reasonable cause, I was proposing to put that in. So everyone commits an offence who, without reasonable cause, and then it continues.
Monsieur Fortin?
Alors, Madame la Présidente,
Madam Chair, well, I've thought about this with our wise analysts, and instead of putting it in after everyone, then it would actually say everyone commits an offence who, comma, without reasonable cause, repeatedly or continuously engages, etc. So in English.
offense ou without reasonable cause, comma, repeat, and all the rest, tout le reste du paragraphe.
And then we continue with the paragraph. So in English, to put without reasonable cause before repeatedly. And in French, it would read, quiconque se livre sans cause raisonnable. And then we would continue with the text.
I'm not sure I'm clear.
Okay, I'm going to ask that it be reread here from the table because I think one of the words you used was not correct in English. Just a second. No, okay. We're going to reread what we think you are saying. Just give us a second here. Go on.
Merci, merci Madame la Présidente, merci Monsieur Fortin.
Thank you, Madam Chair. Thank you, Mr. Fortin. So the sub-amendment in French to 64.011, everyone commits an offence who, without reasonable cause, comma, repeatedly or continuously engages in controlling, etc. And in English.
.011. Everyone commits an offense who, comma, without reasonable belief, comma, engages. Without reasonable cause, sorry. Without reasonable cause, comma, engages in a pattern of conduct referred to in subsection 2. Thank you.
Madame Gladue, did you have something on that?
Yes, just to say that, yes, I agree with that, putting that in there.
Do we not have to deal with this? The amendment he just put forth. Just the sub-amendment. But it's, yes, once we deal with the sub-amendment, then you're the first one on the list on the actual amendment. But I now have to deal with the sub-amendment. Can I ask our witnesses if they have any explanatory comments, please, on adding in English without reasonable cause and then commet une infraction quiconque se livre.
Everyone commits an offence who, without reasonable cause. So if we add without reasonable cause.
And what was it? 264.011. Yeah. Do you have any explanatory comments that you can shed with us?
I would just note from a technical perspective.
Technical, that's the word, technical, yes.
That the way that the bill or the amendments are drafted now imports the reasonable analysis to the third conduct of category of conduct only, the one that is largely non-criminal in nature, putting without reasonable cause in the chapeau of 264.01 sub 1 would allow that analysis to also apply to conduct that is criminal as defined in A and B, so violent and sexually coercive conduct. So that's my comment from a technical perspective.
So are you saying somebody can commit a coercive sexually, whatever the word you used, if if they commit the offense without reasonable cause? I'm sorry, can you explain again what you just said?
Yes, it does open the door to that argument. I'm not sure it would be successful, but it opens the door to that argument because engaging in a pattern of conduct without reasonable cause, where the pattern of conduct is defined to include sexually coercive conduct and violent conduct, opens the door to arguments that engaging in that conduct could be done with reasonable cause. Thank you.
Ledoux?
So could you give us an example of where somebody could justify that they had reasonable cause to commit a violent or sexually assaulting act?
Madame Levin, can you, I don't know the answer to that, I guess the fear is we're trying to get a technical explanation is that a possibility?
As per my previous remarks, I think it would be highly unlikely to succeed, but it opens the door to that type of argument. And that is why the reasonableness test is built into the third category of conduct, which tries to identify and target more subtle forms of coercive conduct that aren't necessarily criminal offenses in and of themselves. And that's why you have the objective reasonable test there. To help the court and other criminal justice practitioners identify what types of conduct could amount to conduct that would reasonably be expected to cause the intimate partner to believe their safety is threatened.
Madam Chair, I guess the more I'm listening, the increasingly frustrating this whole process is, and I'll tell you why. G2 is not an amendment to this bill. G2 is an entirely new bill. So backing up a little bit, in April of 2021, so 3 years ago, this committee agreed that the government should act on controlling and coercive behavior, including in the criminal code. MP Collins, an NDP member, and Mr. Garrison brought forward Bill C-332. We have had 3 days of witness testimony on C-332. Members of this committee took hours of time to develop amendments to Bill C-332. If you look at G2, including ourselves, we have an amendment to increase from 2 years to 5 years the time period whereby someone could reflect back on a relationship and achieve a conviction under this legislation. That was based on testimony we heard on 332. We have not heard one moment of testimony on G2. We haven't had the ability to have a witness appear and say, I agree with clause 1, 2, 3, and 4. I don't agree with clause 5. It's never been put to them. So if you look at Bill 332 and you look at G2, this amendment is bigger than the bill itself. The bill's less than 3 pages. The amendment is 3 full pages. So I think what we're doing now, and now Mr. Fortin is rightly, he's on the fly, as all of us, trying to reformulate amendments based on what is before us. And that's not the way we're supposed to proceed. We have one amendment that wipes out all of our other amendments and wipes out all the consideration that we heard on this bill. So I can tell you, like, for my part, I will be voting against G2. I'm going to vote in favor of Mr. Fortin's amendment once we figure out that it should only apply to the non-criminal actions. But once we get to that point, and it's taking us forever to get there because of how this whole process is unfolding. So I think we should have had, if the government wanted to bring in their own bill, they should have brought in that bill, and then we could have heard expert witnesses on that bill. Instead of bringing in their bill through an amendment to a private member's bill that we've spent all this time considering. So, for example, with Bill, with the amendment in G2, based on the testimony I'm hearing from our witnesses, and this is not a reflection at all on our witnesses, because they're here to present what the government amendment is, and they're doing a fantastic job of it. But based on what I've heard, a pattern of behavior or conduct can be 2 times. And based on that witness, on the testimony we've heard, a number of the items in this are non-criminal in nature. So by my interpretation of that is if someone in a relationship does something twice that is non-criminal, proof of fear is not required, and that person is the vulnerable individual in a relationship, then we could have criminal action. And it's so easy to contemplate scenarios under here where the threat of criminal action or a criminal charge could be brought. I think Ms. Gladue mentioned one, and I see this all the time in relationships where one person is saying, I'm not taking my medicine, and the other says, the doctor prescribed you this medicine, we're not leaving the house until you take your heart medicine. And the person said, well, I'm tired of this, I'm tired of the way this has been going, and I'm not taking my heart medicine. I said, well, we're not going anywhere until you take your pills. If you think that that doesn't happen a million times over in Canada, it does. And we've now the evidence that we have here might be that, oh no, that wouldn't be captured. But that's exactly what Mr. Fortin's amendment's trying to do, is saying, well, that's reasonable. We understand what we're trying to get to. We're trying to get to the person that says, I won't give you your medicine unless you do something. That's coercive. That's threatening. But, it's not based on any. We heard testimony today. It's not, proof of fear is not required. That same person could then say, you know what? If you keep pushing me to take my heart medicine, I'm gonna end it all. I'm gonna jump in front of a bus. I'm gonna threaten suicide. That's prescribed in here too. Is that a criminal act? Who's the vulnerable person? The one that needs his heart medicine? The one that's threatening suicide? Are they both vulnerable? And I raise that as just one real life scenario that we were unable to hear any expert testimony on. There was a tremendous number of really great witnesses that came forward on 332, but they didn't come forward on G2. So amendments normally at this committee are very direct, very focused, but this is a complete rewrite. So I guess, Madam Chair, I'll be opposing G1. And in favor of G2, I'll be opposing G2 in favor of the language that was less prescriptive. We heard testimony as to whether to be more prescriptive and use examples or to be less prescriptive. We have language in here. We have a bill that is the result of a study that this committee did, unanimously passed in 2021. I applaud any effort to improve the bill. But to ask us right now on the fly to come up with amendments to a total rewrite of the bill that we've heard no testimony on, I reject it. I reject it as our committee should not proceed in this fashion. So it's for those reasons I will be opposing G2 in favor of the current reading on 332, and that will further enable us to have some of our amendments that are focused on 332, have us consider those amendments, which according to what you've said, Madam Chair, if G2 passes, most of our amendments, both BQ and liberal and conservative amendments, go out the window. And at this point in the meeting, I thought we'd be done. I really did. Based on this bill and the support for 332, I thought we'd be done. But in order to do our job, we need to keep going the way we're going and parsing out each one of these elements. So I'm going to be voting against G2, and I would urge my colleagues around the table to do that so we can get on with our consideration on 332. If the government later wants to bring in a new bill on coercive and controlling behavior, they are welcome to do that. They've had 3 years to do that. But this moment in this committee, when we have less than an hour left, this isn't the time for us to draft a bill, which is what we're doing right now. We're drafting a bill out of thin air.
I'll save my comments and questions until we hear everyone else. Mr. Garrison? Yep. No, Mr. Garrison. And yep.
Thank you very much, Madam Chair. There was some quite general things that are stated there, so I will get to Mr. Fortin's sub-amendment. But I think, with all due respect, it mischaracterizes what's gone on in this committee. So what is in G2, from my point of view, is the original offer of the bill, and I know from very quick consultations just now with Ms. Collins, reflects the testimony that we heard and reflects the consultations that took place. So it's not true that this appeared from nowhere, and there were always two approaches to the bill, to have a more exhaustive list in the bill, or to have those things in prosecutorial guidelines. The original bill suggested they would be in prosecutorial guidelines, not in the bill. We heard testimony on that. It's not that we've never heard about this. And so I do not believe it is a complete rewrite of the bill, and I believe it addresses many of the things we heard in consultations and in testimony before the committee, in particular for the survivors of coercive control. And I know we can all imagine scenarios, but in fact, we have coercive control being used by male partners against their female partners very extensively in this country, and it is almost always, in cases of femicide, the precursor to femicide. So it's a crisis that's going on. And yes, we've been dealing with this. I made my first attempts to bring this to the committee's attention 4 years ago. However, we knew the amendment package was coming, and I believe we had time to have a look at it. I think this package does some important things, and the concerns that were raised about the amendment about whether it should be 2 years after to 5 years after. This amendment goes with the word former, which will include even after 5 years if a judge thinks that's appropriate. So it has addressed that concern which was in that amendment. I could go on with a number of others. I think there's two really important improvements here, and that is the test of what someone would be reasonable to believe. That's something we heard from survivors and we heard from other experts. And we've also had, in the intervening 3-year period, the benefit of experience in other jurisdictions, which this bill reflects. And the final one, I think, which is most important to me, is in subsection 3 of G2, which introduces the vulnerability clause, which should help address the very serious concern that many had that this bill could be used against the victims of coercive control by a controlling partner. And the vulnerability test that's introduced here, I think, largely helps answer that question. So when it comes to the specific sub-amendment of Mr. Fortin, I think it has an inadvertent consequence, which would be to change the arguments in the initial cases of coercive control to be about whether criminal acts were reasonable or not. And I don't think that's a door we should open in this committee. I accept the testimony of our experts that this bill does cover the reasonableness in 2 other places, and it narrowly applies them to the 3rd category and not to the criminal acts. So I would be opposing Mr. Fortin's amendment, and I would be urging us to move forward. I would reject the arguments this is a completely new bill and came from nowhere. It came from the consultations and the testimony that we heard before this committee. I believe it's a better version, and I believe it will more effectively address the concerns of those survivors we heard before this committee. Thank you.
Thank you. Mr. Rampapta?
Good, thank you. Thank you for your testimony. It's very clear, very helpful. But I have 2 questions. First of all, related to Section 264.01 A and B, the intent section, or the mens rea section. And I think that you were saying that this wording does not require proof of actual victim fear. It's an objective test. I accept that on face value. But then I look at subparagraph C on the next page, and you use the word could reasonably expected to cause the intimate partner to believe. So what's the difference? Like, why are you using that phrase could reasonably expected to cause the intimate partner to believe in section C, but not also in A and B? That's my first question. And I'll just throw out my second question here. Following up on what Mr. Moore was saying about having this list, 7 items under subsection C, and my fear is that when you draft a list, maybe you're missing something. Maybe maybe there should have, instead of 7, there should have been 8 or 9 or 10 examples, because sometimes by including a list, you're limiting the scope of the bill. This came up in a study earlier this session in October on S12, the Sex Offender Registry, and Dr. Robic, Federal Ombudsman for Victims of Crime, and Professor Benedette they were concerned how judges were misunderstanding sexual offenses, and they were worried about rape myths creeping in. And they said Parliament could respond by setting out a list of factors for judges to consider. We put forward a motion to that effect, and Mr. Maloney had this to say. I remember the evidence because I think I was the one who actually asked the question, but in my experience, the more you include, the more you exclude, because crafty lawyers will see a list and then argue it's exhaustive. So that's a concern. I thought it was a good comment at the time. He almost convinced me to vote against her own motion. But and he can comment on that if he wants. That's not the point. My question is whether, taking a look at paragraph C, if we take out the words between the hyphens, including conduct listed in any of the following subparagraphs, and then exclude all the subparagraphs, have we completely gutted the intent of paragraph C, or is it still effective?
So thank you, Mr. Van Popta, with the two questions, and I'm now going to ask Madame Levman to please comment on those from a technical perspective.
Yes, well, paragraph C is obviously creating a non-exhaustive list, and that's being informed by what we heard during the course of Justice Canada's September-October 2023 engagement, as well as much testimony before this committee as well. If my colleague Ellen, could you provide the committee with some information on what the concerns were of stakeholders and why they felt an illustrative, non-exhaustive list was critically important?
Thank you. So of the stakeholders who engaged and supported or engaged in the alternative for coercive control and fence, one of the significant concerns was implementation, law enforcement, criminal justice practitioners, and including a list in the offense itself would help guide the application but not limit it. It would ask criminal justice practitioners to look at this type of conduct or similar conduct. And they also referenced the human trafficking offense, which has such a list that the Ontario Court of Appeal has since developed further indicators for. So it did not limit it. It has continued to expand as they see new cases and new abuses of vulnerability.
That sort of answers my question, but my question really is, have we completely gutted sections, paragraph C, if we exclude the list? Just get rid of it altogether, including the words, including conduct listed in any of the following subparagraphs.
I guess what we were trying to imply, but I'll state it directly now, is that if you were to do that, that would be inconsistent with what we've heard from stakeholders, including survivors who wish to see their lived experiences in the legislation and feel very strongly that criminal justice practitioners need to know what types of conduct, that more subtle forms in particular, not the violence and the sexually coercive stuff, but the more subtle forms should be highlighted in the legislation. So if you were to remove that, you would no longer be responding to stakeholder concerns in that regard.
As we are not responding to Dr. Robic's and Professor Benedette's concerns in the previous study. But, my first question was, why the difference in wording between 264.01 A and B and C? The could reasonably be expected to wording. Why not have it in all three subparagraphs?
Because sub 1, 264.011, A and B articulate the mental element of the offense. So that's about what's going on in the accused's mind. And If you look at Scotland's approach, you'll see that it's very, very similar. Scotland uses the concept of harm. We use the concept of safety in the criminal code. I believe they're meant to capture the same type of conduct, but the way in which the intent element is crafted, intent to cause a particular effect, and reckless as to whether the conduct would lead to that effect is the same. So that's the inquiry is about what's happening inside the accused's mind at that stage. Then when you move to the act element, you're looking at the actual conduct itself. So, for example, monitoring a person's finances, well, we all do that. And when we're in partnerships, we do it for each other often, but that cannot constitute prohibited conduct for the purposes of this offense unless it could reasonably be expected to cause the intimate partner to believe their safety is threatened. So that's where the objective element occurs. Now, evidence of a person engaging in the prohibited conduct, whether that be the more subtle forms or the violent, sexually coercive forms, from that type of evidence, courts can infer the mental element, intent, for example, to cause a person to believe an intimate partner to believe their safety is threatened. Obviously, the more evidence you have in that regard, the easier it will be for courts to infer intent. But both have to be made out for the offense to be proven beyond reasonable doubt in a court of law.
Thank you. Madame Gladue?
Thank you, Chair. To Ms. Levman, through the Chair, I do take your point about the reasonableness being there in 2C so that it applies to all of the sort of non-criminal offenses. So with that in mind, I'm not going to support Mr. Fortin's amendment. But what I think it's important for people who are watching this clause-by-clause review to understand what happened here is that the government has brought G2 Friday morning, and G2 replaces line 6 on page 1 all the way to line 6 on page 3. Well, the only thing that's before line 6 on page 1 is the title. And the only thing that exists after line 6 on page 3 is nothing. So, in fact, it is an entire gutting of the bill, putting forward another bill, which they already had 3 years to do after the last coercive control study, and we had no witnesses speaking precisely to this bill. So I also am concerned about the process and will vote against G2 on that basis.
Okay, so having no other witnesses, we do witnesses, sorry, speakers. Monsieur Fortin, oui.
Merci. Je croyais que vous aviez mon nom sur la
No.
liste.
Thank you. I thought you already had my name on your list. No, I'm not going to rehash the argument on the sub-amendment that I proposed. And the more we speak about this, more I think it would be wise to do this. But I've listened to Mr. Moore, and in the list under C, it says about a threat to actually die by suicide or to self-harm. That's under Little Roman 7. So that means that if someone says, for example, to their spouse that they want to commit suicide, or if he or she wishes to or threatens to self-harm, and that the spouse in question believes that their safety is threatened, if I think that my safety is threatened, that's because my partner is threatening to commit suicide, it then becomes apparently a criminal act. I'm finding it hard to track on this, because if someone is threatening to commit suicide or to self-harm, well, I'm not a physician, but I imagine they need help. They need to go and see a doctor or a psychologist to help them. They don't need to be told that there's a risk that they'll be sent off to prison for 10 years. I don't imagine that's what you're aiming to cover, but that's what's said here. And that's part of the issues that I raised at the outset. And I understand that my Conservative colleagues are supporting these issues. Namely, it's a new bill. I understand that on the Liberal and the NDP side, you have worked on this for several weeks or perhaps for several months. But for the rest of us, well, I just read it this morning, and that is bothersome for me. And when I read that someone who's threatening their partner to die by suicide or to self-harm, well, I imagine they're cutting their skin or flagellating themselves. I don't know. If the partner or spouse of this person believes that their security is under threat, then this other person could be sent to prison. I'm finding it hard to follow the reasoning. Could you perhaps tell me clearly what this is driving at?
Oh, Madame Levman, yes, I'm asking again to please give us some technical support here on the questions that have been raised, and I think you're about to do that, so please proceed.
Certainly, Chair. So, in the circumstance that Monsieur Fortin has described, you'd have a person who has threatened suicide or self-harm, and that act, let's say, a court has found could reasonably be expected to cause the intimate partner to believe their safety is threatened. That could form part of the pattern of conduct that is the act element of this offense. But in addition to proving the pattern of conduct, a prosecutor will also have to prove the intent element, intent or recklessness, as I've already described. So it's not technically accurate to say that one act of threatening suicide that implicates the intimate partner's safety would result in a conviction. The offense is more rigorous than that. It requires proof of the accused having engaged in a pattern of conduct of which that could form part, and also having the requisite intent element as per proposed subsection 264.011. Thank you.
Merci. Mais dans ce cas-là, Madame Levman.
Thank you. So in that case, Ms. Levman, can you give me an example, please? Just one single example where someone could be found guilty for having shown this conduct under 7, threatening to die by suicide or to self-harm. Can you give me an example of a situation where they could be found guilty of having committed this offence under this clause?
Well, I'm not a prosecutor, but I do understand the components of this offence. And what we heard during our engagement process was that this was one of many tactics that people who engage in coercive control of their intimate partners engage in. So it would be part of a pattern of conduct, let's say, that may involve violent behavior, sexually coercive behavior, and other forms of coercive conduct that are more subtle, like surveilling, monitoring the victim, or denying them ways to express themselves, for example, through their culture, their religion, etc. It's a pattern that takes place over time. And I would just make a quick comment that this is very modern criminal law. This committee has already heard extensive testimony about the criminal law being traditionally incident-based. This is trying to go beyond that. It's trying to capture patterns of conduct that takes place over time. And because of that, it's been inspired by the other offense in the criminal code that also attempts to target conduct that takes place over time, and that is the human trafficking offense. And there we also see lots of different coercive type conduct being engaged in by an accused in order to exploit a more vulnerable person. So it's similar in that regard. But we are looking at a pattern of conduct, which means that you cannot ground a conviction on one incident. It's not possible to do so, given the way this offense is constructed.
Thank you.
Thank you.
Thank you.
Donc,
Oops,
Oui,
Monsieur
continue.
Fortin.
Can I please continue? So if I've correctly understood then, Ms. Levman, there is no example there. Or perhaps I've misunderstood, but it seems that if someone says to their spouse, I want to commit suicide, or for one reason that I can't even imagine, I want to cut my wrists or cause scars to my body. So in no case a person who has that sort of conduct would be found guilty of showing coercive or controlling conduct. Is that correct?
That in and of itself would not be enough to ground a conviction, no.
alors pourquoi on a l'article 7 si ça peut...
So why do you have a Roman 7 here if that doesn't apply? Why has it been included?
Like all of the other examples of conduct in that list, in the paragraphs there, they are the types of conduct that we heard through our engagement process. Justice Canada's engagement process are the types of conduct that are usually engaged in by people who seek to coercively control their intimate partner. But the offense is constructed carefully to avoid criminal conviction for any one of those, commission of any one of that type of conduct. Also, the safety test would have to be met before it could even be considered prohibited conduct for the purposes of the offense. And then you need more than one incident in order to establish a pattern of conduct according to the act element of the offense, plus the intent element as well would need to be proven.
Parce que moi, ça me pose...
Because that does cause a problem for me, because we all think we're creating new law, and it's not civil law. We're talking about sending someone to prison to find someone guilty of having committed a criminal act. And I was ready to vote on this bill, C-332. I believe that an individual who's unjustifiably trying to control their partner, their spouse, and we've heard many witnesses on this type of conduct. I'm very shocked by that type of conduct, and I believe that it needs to be addressed in the criminal code. But unlike C-332, if we look at this list here, and I think I'm perhaps repeating what Mr. Moore has already said, I don't want to just speak for the sake of speaking here, but under the list, see it says engaging in any other conduct, including conduct listed in any of the following subparagraphs. And these subparagraphs will be used for interpretation purposes, so to decide whether we want to punish someone or not. And with such a long list, if a partner says to their partner, I want to commit suicide, apparently they could be accused of having tried to exercise coercive control over them. If you don't come on vacation with me, I'm going to commit suicide. Well, it seems that that individual would then be sent off to prison. And perhaps if we heard from witnesses, expert witnesses on this, we've heard from several, perhaps we could bring them back to talk to us about this. Perhaps they would convince us, I and perhaps others are around the table are convinced that coercive conduct has to be tackled. It really doesn't add up. But with this new list, I feel as if I'm on very shaky ground. We're taking a very significant decision here. We want to amend criminal code and create a new offence. So as legislator, we have to act with caution when we do this. And I really feel that we're not exercising caution here. I'm convinced the good faith of our witnesses today and the good faith of the government also. But personally speaking, I'm far from reassured when I see this and when I've not had the opportunity to turn to experts who are working on this on a daily basis with victims and with their aggressors. When it comes to coercive conduct, we have to look at the two sides of this. We have to look at that and exercise due diligence. But I have the feeling, as I've said, that we're working on shaky ground here, and I really regret that. And with the questions that I've raised, it seems that we cannot even give me one single example where we could find someone guilty of showing coercive conduct because he or she has threatened to commit suicide or to self-harm. So if we can't even get one sole example when we're about to legislate on this, what are the courts going to do with this? I really don't think it would be reasonable for us to proceed in this way. Thank you, Madam Chair.
Mr. Moore?
Thank you, Madam Chair. Just to expand on that a little bit, here's the problem. Madam Levman, you've mentioned that the government heard about this particular aspect. And I can tell you, in the witness testimony that we heard, I don't remember hearing that. And I'm not doubting that you heard it, but and maybe someone did, or maybe someone at the table can correct if this became a theme from the witness testimony we had on 332. But it's introducing an element to us, and I do want to take, just to clarify one point. You mentioned, Ms. Levman, that this would have to be a pattern. There's nothing in my read of this legislation that suggests the pattern of behavior has to include multiple of these elements. Your testimony was that a pattern is at least twice. So my read of this bill, and I'm going to call it a new bill, Bill G2, my read is that everyone commits an offense who engages in a pattern, which means two or more, of conduct referred to in subsection 2. And B, being reckless as to whether that pattern could cause their intimate partner to believe that their intimate partner's safety is threatened. And a bunch of terms in there that could be broadly interpreted. So then we go to what are those items of conduct referred to in subsection 2? That includes, we go all the way down to 7. Threat, for example, because this is the one that Mr. Fortin was talking about. But I could use others from this list. Threatening to die by suicide. So that tells me, if someone threatens twice to kill themselves because of maybe they're in a fight with their spouse or intimate partner, they're arguing back and forth over something, could be anything, and the person says, well, I'm just going to kill myself and end this. And then a couple weeks later, fight over something different, they say it again. The testimony we heard today is that by doing that twice, that's a pattern. It's a pattern of non-criminal behavior, because that's what we're talking about here. We're not talking about criminal behavior, we're talking about non-criminal behavior that by virtue of it being a pattern and falling under this legislation, now it is criminal behavior, because this is the criminal code. So by doing these non-criminal things in a pattern, we, with this bill, are criminalizing them, which means we have to be very careful. Like the criminal code, there's criminal thresholds around evidence and the things that we choose to include as Canadians as criminal. Then there's a bunch of items in here that your testimony is they're not criminal. Threatening to kill yourself is not criminal. By including it in this list, we are criminalizing it in the context of coercive control. We're making that decision without hearing any testimony about it. But I want to, you mentioned that what the scenario I described would not be criminal because it would maybe have to involve some of the others. But just to be clear, my read of this, there's nowhere in this legislation that you have to do any multiple of these things. It could be the same offense For example, around finances or around access to health services or around threatening to die by suicide, the same offense, a pattern of that, could be captured under controlling behavior. We don't have to have multiples. Is that correct? Because nowhere in the bill does it say it has to be more than one of these. Through you, Chair.
Thank you, Mr. Moore. Madame Leveman?
So Chair, if we look at subsection 264.01 sub 2, which is the definition of a pattern of conduct, it says a pattern of conduct consists of any combination or any repeated instances of any of the following acts. And then it lists the 3 categories of different conduct. And so, yes, it is possible to establish coercive control based on numerous incidents of conduct that are enumerated in paragraph C, provided that they could reasonably be expected to cause the victim to believe their safety is threatened, which is consistent with what I understand to be the overall objective of a coercive control offense, which is to ensure that coercive and controlling behavior can be the subject of a charge and a conviction, regardless of whether other criminal offenses are also committed.
Thank you for that. Madam Chair, I guess the question we have to ask ourselves, I mean, and I'm glad Mr. Fortin raised this particular one, is do we as a committee, based on just this meeting today, not based on 332, not based on any of the witnesses that appeared before us at committee, are we going to make the conscious decision that in Canada from now on, if you threaten to kill yourself multiple times, that's a criminal offense? Because that's what we're doing here. And it could be that we would hear enough testimony from different groups that would lead us to the conclusion that, yes, there is a way that that could be incorporated. The problem is we, around this table, have not heard that. And I do think, by plain reading of this legislation, that that and some of the others are quite troubling, which is why the whole, and this is, again, not a reflection on our witnesses, but it's more directed to the government, the whole approach of introducing a bill that we haven't had. And I heard what Mr. Garrison said. Yes, we heard general testimony about 332, but we have not had the chance to specifically ask anyone about any of these specific provisions. For example, I would like to have witnesses here where we were able to ask them about each one of the itemized new non-criminal offenses that through this bill would now become criminal. So I guess that last one, Madam Chair, I'm just raising as a point to reiterate that at this point, unless we were going to, unless there's people here that are going to enlighten us through more testimony on each one of these provisions, that I would have to vote against G2 and support the language that we've already considered and already had witness testimony on, which is 264.011 of 332. I think I did not hear witnesses say, you got that wrong. This bill is not going to be helpful. We heard some testimony that said there's models that itemize some things, but threatening to die by suicide was never suggested at this committee. So words matter. This is by the testimony of our witnesses here today, this is criminalizing non-criminal behavior in the context of coercive control. So obviously we have to be very careful about what gets added to that list. And this is just one that's been flagged. So I don't see how we could be ready to proceed with G2 on that basis alone.
Monsieur Fortin.
Merci, Madame la Présidente. Une autre question.
Thank you, Madam Chair. I have another question. While reading this, G2, while reading it, when it comes to paragraph 5, the last paragraph of G2, it says, For the purposes of this section and for greater certainty, a person's safety includes their psychological safety. Could you please explain what you mean by that? I've got several friends who suffer from anxiety. It seems that there are many people nowadays who are suffering from anxiety. I don't have any competence to analyse why and the harm as a result of suffering from anxiety. There's lots of different reasons behind this, and some people might consider that there's valid reasons, not valid reasons for suffering from anxiety. In any case, it's all very subjective. So when we say that we're addressing psychological safety of individuals here, does that mean that each partner would be responsible for the psychological safety of their partner? I imagine that's not what you're driving at, but I haven't had time to really think this through. To repeat that once again, we're just reading this for the first time this morning. So how far do you want to go with this term of psychological safety? What does it cover, and what would the consequences be if a spouse or partner has psychological issues? And as we know, this is a pretty vague term, psychological safety, that really varies from one individual to another. We all have different limits. So I'd like to hear from you on that, please.
Yes, Mr. Garrison.
I believe Mr. Fortin has a sub-amendment on the floor, and we've strayed considerably far away from his sub-amendment. So I would suggest we need to deal with the sub-amendment. And then if people wish to continue to ask questions about G2, which don't appear to change their opinion of it, that's their prerogative. But we, I believe, still have the sub-amendment on the floor.
You're on the rush to reject my amendment.
So that's correct. We can't deal with the amendment. We cannot until we deal with the sub-amendment. So can I ask that we vote on the sub-amendment?
Puis-je avoir la parole?
Oui, Monsieur Fortin.
Could I please take the floor? Madam Chair, I very much understand my colleague, Mr. Garrison, that we've strayed quite a bit from my sub-amendment. I completely understand that. But the sub-amendment that I was proposing was saying that the offence could only be committed if there was reasonable cause. And I'm interested in everything else that flows from that, because there's a real cause for concern to see whether it's important to have reasonable cause or not, because we really need to understand the scope of this. So to come back to what I was saying on psychological safety, we're saying in the bill that it's going to be taken into account. And if this is very broad, and I have the impression it's very broad, then it seems that we're saying it's an offence only if it's committed without reasonable cause. So I do understand, Mr. Garrison, that you want us to vote on my sub-amendment, but first I'd like us to understand the scope, the full scope of this new bill, and is it wise or not to add in this guardrail and say only if this offence is committed without reasonable cause.
Merci beaucoup.
Thank you very much for that, Mr. Fortin. So I would like to invite us now to vote on the sub-amendment. The witness cannot answer my previous question before we vote. You still have another question? No, I put my question already, but I didn't get an answer. I was talking about the scope, in particular of Section 5, or Paragraph 5, where it said, for the purposes of this section and for greater certainty, a person's safety includes their psychological safety. I won't repeat everything I've already said, but I did want to hear from the witnesses from the Justice Department to explain what exactly this actually covers. What is the scope of this section, please?
Madame Levman.
Madam Levman, please go ahead.
Thank you, Chair. I would just point out that the term safety is already used in the criminal harassment and human trafficking offences and has been interpreted by appellate jurisprudence to include psychological safety. In that context, it has been interpreted to cover scenarios such as in the Sinclair case, 2020 Ontario Court of Appeal, that involved a person who was trafficking a young woman. He did not use violence against her. However, she was economically disadvantaged severely, had drug-related issues, and had no place to live. And so because of that, she felt that even though he didn't use violence or threaten violence, that she had to do what was being asked of her, or else she would lose her place of her home where she lived and her ability to feed herself. So those are the types of scenarios that are captured by psychological safety. And I would also point out that Scotland, New South Wales, and Queensland, I believe, all three of them use the term harm and include psychological harm. So it is a term that has been used both in Canadian criminal law jurisprudence as well as in other jurisdictions whose models we are looking to when we craft these offenses. Thank you.
Je peux continuer, Madame la
Can I please continue, Madam Chair? And I don't want to waste the committee's time. I just want to really understand this. And I promise that I will be well behaved, but I do want to understand this. So it says, engage in any other conduct, including conduct listed in any of the following subparagraphs, if, in all the circumstances, the conduct could reasonably be expected to cause the intimate partner to believe that the intimate partner's safety, the safety person known to them, is threatened. So reasonably be expected, and it refers to the context of the circumstances. And then under 5, it introduces this notion of also including psychological safety. So to come back to my example, if someone has a partner who suffers from anxiety, and I'm not criticizing this. I've got close loved ones who suffer from anxiety, and I have full respect for them. I don't want to criticize this at all. I just want to see how we could enforce our legislation here. For example, if my wife, now this isn't the case, but if my wife or spouse were to suffer from anxiety, and I have one of these conduct, for example, trying to control the way her manner of dress, or I threaten to commit suicide, and if she suffers from anxiety, then of course she's going to be even more concerned by this conduct because she already suffers from anxiety. And C says that we have to take that into account. It's part of the circumstances. Are we not further opening the door, further enlarging the cases where this would establish an offence? There's such and such a conduct, and given the circumstances, and given that your spouse suffers from anxiety, it was reasonable. You should have expected that. When you said that you wanted to commit suicide, you could reasonably have expected that that would have had an impact on her psychological safety. Now, I know you're not a psychologist, me neither, but we don't have any psychologists here. So what do you think about this? Are we not really opening wide the door when it comes to the zone to be covered? We're going to actually establish that a crime has been committed.
Ms. Levman?
So what you're pointing to is a potential prohibited conduct that would have to be looked at through the reasonableness lens, which is objective but specific to the circumstances of that particular incident that you've described. So the anxiety of the person would have to be taken into account when determining whether or not that conduct could reasonably be expected to cause the person to believe their safety is threatened. But in addition to that, you also have to prove intent to cause the person to believe their safety is threatened, or recklessness as to whether or not your conduct would cause that result. So there are multiple layers of different items that would need to be proven, including a pattern of conduct. So it couldn't be just once that, you suggested something that your partner who suffers from anxiety do or not do. So like I said before, we're dealing with ongoing conduct. No one incident in and of itself can ground a conviction for this offense, and everything has to be placed in the context of the relationship as a whole, has to be considered in the context of the relationship as a whole, which I believe is the provision that Mr. Garrison referred to earlier on proposed 264.01 sub 3, which provides another layer of protection to ensure that cases where there are two equal partners helping each other with problems are not caught by this offense. Thank you.
Merci, Madame Levman. Et
Thank you very much, Ms. Levman. And then to come back to everything that's been discussed, in Mr. Moore's example earlier, where a male or female partner says to their partner, "We will not leave the house before you've taken your medication," well, that there are these other levels that come into account, as you've said. But for example, if you've got an individual who says to their partner, you know, you need to take your medication, otherwise it's going to be dangerous for your health. You could die if you don't take your meds, and I really love you, and I couldn't live without you. So if you don't take your medication today, that's it, I'm going to commit suicide. So they're actually committing an offence vis-a-vis this other person. And now I know I'm pushing the envelope here, but you're committing offence vis-a-vis someone whom you already know is fragile. They're suffering from anxiety. They're refusing to take their medication. And I'm saying, if you don't take your meds, then that's the end of it for me. It's a real shame, but I'm going to pull the plug. I'm going to commit suicide. Then they would be committing an offence. And we're not sending them to the doctor. We're sending them to prison. Don't you think that's a bit abusive in and of itself?
Ms. Levman?
Again, that conduct couldn't be considered prohibited conduct unless it met that reasonableness test in the circumstances. So it may or may not be prohibited conduct.
je m'excuse, je veux pas.
Sorry, I didn't want to interrupt you, but time is ticking. That's not what I was driving at, the reasonableness element. You're saying, is it reasonable to be expected, given the circumstances, to believe that the intimate partner's safety or the safety of the person known to them is threatened? Isn't reasonable to expect that the partner considers this? Because if I say to my partner, take your medications, otherwise I'm going to commit suicide, I'm saying that because I think it's going to have an effect on her. So it is very reasonable to expect then that within these circumstances, she would believe that my person is in safety, my person who is in safety, but we're trying to see whether this has been committed on reasonable grounds, and that's some sort of guardrail that we're putting in here to see if the conduct, even if it's reasonable, and it's very reasonable to expect that the person would believe that their safety is being threatened, but if it's been done for reasons or grounds that are considered reasonable by the court, could we not then exempt them? That's another level, as you would say, another level of proof or evidence.
Well, the circumstances will include why the accused or the person is threatening suicide in that case. And I would also underscore that the intent element has to be made out. And although I can't pronounce on what a court would find in a given case, you've described this example as an accused who really is just worried for the health and well-being of their partner and isn't intending to cause any harm, be that physical or psychological. Thank you.
I guess the summary and the takeaway for me, although, is we need to look at the entirety of the circumstances and not simply one of those sections. All sections that are brought forth here in this bill need to be taken together as a whole, whether us in the committee here when we're voting on it or when it goes to court, which in any of the circumstances. So what I'm going to do right now, I am going to ask that we vote on the sub-amendment. And I ask, shall the sub-amendment, and I don't know what number it is.
Just the sub-amendment
just the sub-amendment. So the sub-amendment carry.
Sub-amendment that
That Mr.
applies to-
Fortin brought forth.
Okay, and it
We're not
was-
voting, yeah.
The witnesses said that the sub-amendment would apply also to the criminal acts, which would be saying if it's reasonable. Can you read the sub-amendment in context of the?
So I'm going to ask the table to do that because I think they kind of wrote it. So please go ahead. In both languages, I guess.
Certainly. In English, 264.011, everyone commits an offense who, without reasonable cause, engages in a pattern of conduct referred to in subsection 2. En français, 264.0.
In French, 264.011, everyone commits an offence who, without reasonable cause, engages in a pattern of conduct referred to in subsection 2.
I'm now going to ask for the vote. Would you like to vote individually, or do we? Shall the sub-amendment carry? No. I heard more no's, but would recorded vote, please, Monsieur le Greffier, s'il vous plaît.
On the sub-amendment, Mr. Maloney,
No.
Mr. Hardy,
No.
Mr. Mendicino,
No.
Mr. Housefather,
No.
Madame Dillon.
Non.
Pardon?
Non.
Merci. Mr. Moore.
No.
Madame Gladu.
No.
Mr. Caputo.
No.
Mr. Van Popta.
No.
Mr. Fortin.
Oui.
Mr. Garrison.
No.
Thank you. The sub-amendment is defeated. Now we're back on the actual amendment itself that has been brought forth. G2. So shall G2 carry?
No.
Can we have a recorded vote, please?
On G2, Mr. Maloney,
Yes.
Mr. Hardy,
Yes.
Mr. Mendicino,
Yes.
Mr. Housefather,
Yes.
Madame Dillon,
Yes.
Mr. Moore,
No.
Madame Gladu,
No.
Mr. Caputo.
No.
Mr. Van Popta,
No.
Mr. Fortin,
No.
Mr. Garrison,
Yes.
A6, N5, carried.
G2 is carried. As a result, BQ1, BQ2, BQ3, LIB1, BQ4, BQ5, CPC1, and BQ6 cannot be moved. Since G2 is adopted, we'll now proceed with the question on Clause 1. Right there. Shall Clause 1 carry?
Yes.
Carried on division. As amended. Carried on division as amended. Thank you. New Clause 2, G3. Would the member please move that? Mr. Maloney is moved. Shall G3 carry?
Yes.
Mr. Caputo?
I'm sorry, I know everybody wants to get going, but in my experience, the two most common offenses that this section applies to are actually not listed here. Assault, 266, uttering threats, 264.1, in the context of intimate partner violence are actually the times when, in my experience, these orders are sought. So I would seek, I'm not sure if the Liberals would see that as a friendly amendment, and potentially even 267, assault causing bodily harm, assault with a weapon. I'm not sure if they would see that as a friendly amendment, but I would include those.
The sub-amendment, if, sounds that you are proposing a sub-amendments?
Yes, just to.
And it would need to be provided in writing, but to be frank, can you repeat that again? And I'm going to ask the officials to comment on what you just said.
So after 264.01, to add number 266, or pardon me, 264.1 and 266. And 267, sorry, 267 should be there as well. 264.1.
And Ms. Levman, is what he just said, is that enough for you to provide us a bit of an explanation, or should you repeat that again, Mr. Caputo? Would you repeat that again, Mr. Caputo? What is it you would like us to consider adding?
I think Ms. Levman's good.
Are you?
I think if we're changing the scope of, if we're changing the bill, we should just add the offenses that should be reflected that are most used, this section most uses.
Ms. Levman?
So this provision for 86.3 sub 2 is a provision that prohibits accused from cross-examining witnesses in cases involving certain offenses. The existing list, the law as it is today, includes criminal harassment and the 3 sexual assault offenses. And this is to try to minimize re-victimization by the victim through court processes. We know that sometimes abusers seek to cross-examine in order to continue their abuse of their victims. So this would prevent that. This is a consequential amendment, so all it does is drop 264, proposed 264.01 into this paragraph. What I understand the proposal is to fairly significantly expand it by including uttering threats, 264.1, and 2 of the 3 assault offenses, assault simpliciter and assault causing bodily harm. I think I understand that the intention is to prevent people who are accused of intimate partner violence from cross-examining victims when they are charged with assault offenses, but the amendment would apply far more broadly than that to all assaults and all uttering of threats, regardless of the relationship between the accused and the victim. And again, this is a consequential amendment in relation to the proposed course of control offense.
Okay, if it is,
Before you start, we're checking with the interpreters to see how many minutes we have, because
Okay,
it's
I'll be
beyond
very
1
quick.
o'clock, so we're
because-
checking with them.
because we are beyond 1 o'clock, then I'm not sure, it would seem as though we're getting into territory, according to the experts, that may not have been contemplated and we didn't hear from witnesses on. So I'm not sure if my sub-amendment was formally moved, but I'll withdraw it if it was not then, given what we've heard here. Thank you.
Shall G3 carry?
Yes.
G3 is carried. New clause 3, so G4. Shall G4 carry? Mr. Maloney moved it already. He said yes. Can I group the rest together, or should we go through them separately? So it looks to me like we can.
No, we have to go by UC. So is there UC too?
Is there unanimous consent? Yes, they all said yes. So we've got G5, G6, G7, G8, G9, G10, G11, G12, and G13. Shall all those, they're all moved by Mr. Maloney. Thank you, Mr. Maloney. Shall they all carry? Yes, they all carry. Now I go to the title.
And shall their clauses as amended carry as well? So we've,
None of them were amended. Title, G14.
No.
G14 the title.
The amendment,
Yeah, that's fine.
there is no amendment. So shall the title carry?
No.
No, G14.
You don't want the amendment?
G14 needs to be moved.
I'm asking G14 to be moved. G14 is now moved, so shall G14 carry? Yes, G14 is carried. Shall the title be carried?
As amended.
As amended? Yes, thank you. It's carried. Shall the bill as amended carry? Yes. Mr. Garrison?
May I just take one moment on behalf of the committee to thank all those survivors who came forward, whether in consultations or at committee, to tell their stories. This is a result of that bravery that they've shown, and I know we all wish to thank them.
So, did we move that? So, shall the chair report the bill as amended to the House? Yes. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Am I done? Thank you very much, everybody, and I wish you a pleasant day. Motion to adjourn? So moved. Meeting adjourned.
Thank you.
Thank you.